today he is here to speak about Oregon Senate Bill 282 and give us basically a summary of this Senate bill. So welcome, Charles. Thank you so much for being here.
And Taylor, before we have Charles speak, I wanted to, first of all, piggyback on Scott, and just, you mentioned the absentee owners list. I just wanted to share with everybody that's something that we can do, or I can do for you at Lawyer's Title. So if that's something you're interested in, just give me a call or shoot me an email. And then secondly, those of you that are realtors on here will be getting a credit hour if you'd like one. And you will receive that in a day or two. And this is being recorded. Make sure you are on your own Zoom account so that your name comes up so that we can give you that. And you cannot share if you're wanting that credit hour. I think that covers it, right? Went through everything?
Yeah.
All right. Thank you all for being here. Charles, go ahead. Take it away.
Thank you. So I think I've shared my screen. Can you see the presentation?
Yes.
Okay. So it's been a long year and a half. As you guys recall, on March 13th of 2020, the governor unilaterally said that they would not enforce any eviction judgment at all. And then it very quickly became they weren't going to do any evictions for non-payment or without cause. And then for a while over the summer, it turned into no evictions at all for any reason. And then in the fall, due to the lobbying of Multifamily Northwest, the Rental Housing Alliance, and the Oregon Realtors Association, they allowed 90-day stated cause notices where there was a contract and sale in place to a buyer who wanted to move in and use the property as a primary residence. And that's kind of how it remained through the end of 2020. In the beginning of December 2020, they passed a bill called House Bill 4401 that said that rent was required to be paid in January for January only, and arrears from the year of 2020 could be pursued after March 31st. That got extended, obviously, before the end of March. And in place, they said, okay, there's a landlord fund that's going to pay the landlords 80% of the rent. The landlords have to forgive 20% of the rent, but the tenants have to apply for it. That lasted roughly until May of this year, when some federal money became available, and we're going to go into what that means. But just here at the end of June, the end of May, beginning of June, Senate Bill 282 was passed, and that's ultimately what we're going to be talking about. I will note before we get into it that 2 Fridays ago, there was a non-legislative session. There was a listening session before the Oregon legislature. And they heard a lot of complaints by tenants that, hey, we're not going to be able to pay our rent in July. And we're worried we're going to become evicted. And if we end up being evicted, then we might get COVID. And if we get COVID, that screws up the state's recovery. The legislature ultimately was hoping that they would be able to shame the governor into extending the quote-unquote eviction moratorium. And when I talk about the moratorium, I mean evictions for non-payment and evictions without cause. So far, the governor has not done that. And in a relatively hopeful sign, Julie Fahey, who's a representative from Eugene and is the head of the Oregon House Housing Committee, has just this week introduced a bill that says where a tenant is applying for rental assistance, the landlord cannot evict for non-payment for 60 days. That bill has not passed, but it's a good sign, because what it tells us is that Julie Fahey, at least if she's going to introduce that bill, then she's not certain that the governor is going to again unilaterally extend this. And for obvious reasons, we need business to get back to normal. Landlords have been required to continue to provide rentals, to continue to do maintenance. All the while, they haven't been able to get paid for it. This would be like the governor saying restaurants need to stay open, but they need to serve everybody for free. That obviously hasn't happened. Landlords have been forced to bear the brunt of this pandemic. And as an aside, the federal CDC moratorium has been under assault in federal courts, and whether or not it's even constitutional is currently pending before the United States Supreme Court. Now, again, when I say the federal moratorium, I'm just talking about the CDC moratorium, as well as the Fannie Mae, Freddie Mac prohibition on being able to terminate a tenancy that's federally backed. That one, Fannie Mae, Freddie Mac probably has the authority to leave in place. But the CDC moratorium, it is likely that the Supreme Court will strike that if it's not extended. If it is extended. If it's not extended, then it becomes moot, and then the Supreme Court's going to say it's moot, and they're not going to rule on it for obvious reasons. They don't want to hamstring the ability of the executive branch to come up with rules in response to an emergency. But if it's not extended, then it becomes moot. And there's good reason to believe it won't be extended. The real problem right now, and we'll get into this here, is there's a ton of money available under the current Biden administration. Just within the last 2 months, they've made over $2 billion, with a B, $2 billion in money available to landlords, but it's all being distributed by the states. And the states are so far really unable to distribute the money, which is what's causing the problem. At the same time, Oregon, as of a week ago, was only 70,000 people away from its goal of having 70% of the population vaccinated. And you all know from following the news that businesses are hiring. The problem is they can't get people to take the jobs, in large part because people are on the lower end of the wage scale are making more money right now on unemployment than they are with a job. And so the real problem that we've seen recently is a situation where, I lose my job, I haven't been paying, I submit the declaration of financial hardship to my landlord applies to the state compensation fund, gets paid 80%. Well, then I tell my friends, and all of a sudden my friends who have been paying their rent through the last year plus, they say, hey, why am I being penalized? Charlie didn't pay his rent. Charlie just got a year free. And so we're seeing people that otherwise have been paying their rent now quit paying because they think it's unfair, and they want the landlord to take advantage of available state and federal money. So that's the long-winded version of the background, sort of how we got here now. The declaration of financial hardship is required through June. What the law says is the landlord presently can send a 10-day notice of non-payment instead of the traditional 72-hour notice of non-payment. The landlord can only send that if the tenant has not submitted the declaration of financial hardship, because the declaration of financial hardship is what then frustrates the landlord's ability to do a court case for non-payment through the end of June. Once we get to July, strictly speaking, that declaration of financial hardship is no longer required. However, if the landlord wants to apply to the Landlord Compensation Fund, the landlord needs to submit a copy of that declaration of financial hardship. It may be that for the Oregon Rental Assistance Program, which we'll get into, that's the $2 billion in federal money, it may be that the tenant's required to submit that form. We don't know, because while those applications started to be processed on May 19th, to my knowledge, none of them have been granted yet, because the state Housing and Community Services Department is still trying to figure out how to get that money distributed. So here we go. Since April of this year, the Oregon Housing Community Services Department has distributed, to my knowledge, just under $100 million to landlords to cover unpaid rent, usually in about 3 to 6 month clumps from April 2020 through basically April of 2021. They were running a month or two behind. So what that meant was if you applied in April 2020 for, let's just say, rent from if you applied in April 2021 for rent from November 2020 through April 2021, they would pay you that 6 months, but by the time they finally paid it, it wasn't until the end of May, and then you had to reapply. The trick with that particular fund, which is now in its third round, and the third round for the remaining $50 million, those applications are due tomorrow. In order to apply, you needed to submit the signed tenant 4401 declaration. And again, a copy of that is at the bottom of this presentation. You needed to provide a description of unpaid rent for all of your current tenants, even the ones you weren't applying for. You needed to agree to forgive 20% of the unpaid rent from April 2020 through the date of the application. Basically, you get paid 80%. That remaining 20% is gone. It's voided. You do not get to pursue that remaining 20% from the tenants. You needed to provide the department, the Oregon Housing Community Services Department, with any notices of termination, which of course you weren't able to send any, but any balance due notices as well, or notice termination for non-payment prior to June 30th, 2021. You need to agree to repay to the department any amount that was forgiven by the landlord or paid to the landlord from any other source. You need to agree to not give a notice of termination without cause for non-payment during the application period, and provide any information or materials requested by the department. As I mentioned, round 3 opened in June, and that it actually closes tomorrow. So the reason this bill was written the way it was written was because these bills weren't really thought through in the long run. They were reactionary bills. They were the legislature trying to protect what the legislature viewed as a vulnerable class, ultimately renters. The legislature was panicked that as COVID was going up, the COVID rates were going up, that there'd be a huge amount of people that would become homeless, would end up in the street, and then there would be viral spread that there wasn't anything that they could do to stop. So when HB 4213 originally passed in the summer of 2020, it was set to expire at the end of 2020. So that's why they wrote this bill the way they wrote it, saying that, for example, you needed to give any notices of termination for non-payment. Well, you couldn't give any notices of termination for non-payment. So that was a nullity. So there are a lot of inconsistencies with the way this bill was passed. Without getting into anybody's politics, the Biden administration has taken a much more robust approach to the problem than the prior administration. There's an estimated $2 billion in federal money available through the states and counties. Again, it's been distributed to the same OHCS, the Oregon Housing Community Services Department, but it's going to be distributed by each individual county. The tenant has to apply for that, not the landlord. The website is OregonRentalAssistance.org. So if you have tenants that are behind, mention it to them. There's a couple of big differences. Number one, again, the the tenants apply for it, not the landlord. It's not a loan, so you don't have to pay it back. Because it's not a loan, it will not impact any other subsidy that the tenants receive, such as food stamps, Medicaid, Medicare, Social Security, or public housing assistance. One of the differences with this program is that they will cover up to 12 months of past due rents and up to 3 months of forward rent. It'll cover not just rent, but utilities. However, the tenants have to provide for it, or have to apply for it, have to submit information. The landlord, certainly it's in their interest to cooperate. The fund will reach out to the landlord in theory to ask for corroboration of the debt. But this is a tenant-driven program. And I'll note there has been some federal money available through the counties. The CARES funds that you guys may have heard of, CARES, that was available beginning last summer. That was generally federal money that was also distributed through the counties. If approved, payments will be made directly to the landlord or the utility provider. The funds will be distributed based upon a formula that prioritizes applications based upon need. Everyone who turns in a completed application will have the application reviewed. And again, Oregon is supposed to get $2 billion. So there should be ample money to cover all the applications. The real problem here is that now, at this stage of the game, for the first time, the legislature is concerned about potential fraud. They're concerned about people taking advantage of this program. They were not concerned about that historically. Under 4401, the declarations that the tenants signed were extremely broad. It wasn't just non-payment. It also included increased child care activities, increased care requirements for elderly family members. So what that meant was my wife and I, my wife was working from home, I was still going in the office, our income didn't drop, but yet, and in fact, my wife got a raise, but since she was working from home and the kids were doing homeschool, she had increased childcare activities. So we were eligible to not pay our rent and to apply for these funds. But again, the legislature, when it was just the state money, didn't care about potential fraud submitted by the tenants. They do care now with this distribution of federal money. And we're going to have to see how it plays out, because the money, to my knowledge, has not begun to be distributed. Okay, so there's two parts to Senate Bill 282. There's the eviction moratorium that arose from the emergency period, and then there's the grace period for repayment. The emergency period went from March 13th, 2020 through June 30th, 2021. That has not been extended. So what that means is, beginning July 1st, tenants are required to pay July rent. The grace period was extended, and the grace period is the time the tenant gets to pay back unpaid amounts, the non-payment balance, from March of 2020 through June 30th of 2021. That grace period now goes until February 28, 2022. So on July 1st, your tenants are required to pay rent for July only. The arrears they cannot be evicted for, you can't even pursue those arrears until March of 2022. Now, for obvious reasons, it's in the tenant's interest to apply to the rental assistance program to get that balance paid, not just because in March of next year they'll be able to be evicted or sued for it, but also because the state will pay up to 3 months of future rent. So kind of the free ride for the tenants can go on a little bit longer. The tenant just needs to have the wherewithal to apply. So as I was saying, notices of termination for non-payment for July can be served on the 8th day of the rental period. That's the typical rule. That notice needs to include language that information regarding tenant resources is available at 211info.org. Instead of the traditional 72-hour notice, it's now a 10-day notice. It gives the tenant more time to cure it. Late fees are now applicable. You'll recall for the last year and a half, you've not been able to charge late fees. Those were waived. But for July 2021 and thereafter, late fees apply. While you need to serve your non-payment of rent notice, again, historically a 72-hour notice, now a 10-day notice through the end of February next year, unpaid utilities, security deposits, other amounts arising from the rental agreement, those can be sought with a 30-day notice of termination for cause. After the end of the grace period in February of next year, we get to March of next year, the 10-day notice reverts to a 72-hour notice or 144-hour notice, which is what you're traditionally used to. When Senate Bill 282 was being negotiated, there were lobbyists involved, lobbyists from Multifamily Northwest, the Rental Housing Alliance, a couple of big commercial landlord entities with thousands of units. They participated in the working group. They were told a lot of things that did not necessarily come to fruition in the final drafting of the bill. One might say they were bamboozled a little bit. There are a number of big tenant protections that survived into Senate Bill 282. The section we're looking at here is the historic statute on what a landlord can consider in screening. The bold language is a new change that continues through the end of the grace period, continues through the end of February 2022. So when you're screening a potential tenant, you can't consider an eviction that was dismissed or result in a general judgment for the applicant. You can't consider an eviction that was entered 5 or more years before the application submitted. You can't consider any eviction that arose after April 2020 and before March 1st, 2022. So note, that's really broad. That's not just non-payment. That could include the situation where tenant goes on a meth bender and takes an axe to the property and destroys it. You can't consider that. You can't consider any eviction that arose during the emergency period and the grace period. That was not something that the landlords advocates were told when this bill was being negotiated. They were told repeatedly, landlords will still have all their regular remedies. The purpose of this bill is to protect existing tenants. The bill was drafted much more broadly than that, and there are a couple of other similar changes. Again, historically, you can't consider a previous arrest if it did not result in a conviction. You can't consider a criminal conviction unless it's a drug-related crime, not including possession of marijuana, cursing crimes, sex offenses, crimes that go to dishonesty, such as fraud, identity theft, or forgery. You can't consider crimes that would not adversely affect kind of a landlord-tenant relationship. or that would adversely affect the peaceful enjoyment of other residents, the landlord or the landlord's agents. You can't consider crimes, really any crime involving marijuana, unless it's major distribution. You cannot consider any landlord-tenant judgment or reference for unpaid rent during the emergency period all the way through the end of the grace period. So for a little while there, from end of March of this year through the passage of Senate Bill 282, you could sue a tenant who was already out for their unpaid rent. Senate Bill 282 says you can't. And that actually has broadened the definition. Now, I've actually got one case filed right now for a tenant that left in June of last year, and we got to April 1st of this year, and we filed that case, and that case is pending. And our position is it predated the passage of Senate Bill 282. So that case is okay to go forward. Will a judge agree? Well, we're going to have to find out. The general rule is the law at the time of the filing of a case is what applies. But it is certainly possible, in this particular case is in Clackamas County, it's certainly possible that a judge is going to throw it out based upon Senate Bill 282. A landlord may not report any consumer credit reporting agency any non-payment of rent, charges, or fees that accrued during the emergency period. Now, what does that mean? Well, it's just the emergency period. So if a tenant doesn't pay rent in July and it ends up being evicted for that, that can be reported to a credit reporting agency. So shifting gears a little bit, one of the biggest changes in Senate Bill 82 is not just because of COVID, it's also because of the fires from last fall that really destroyed a lot of the housing stock in the southern part of the Willamette Valley and even a little bit further south than that. A landlord can no longer terminate a tenancy for occupancy violations that are less restrictive than federal law. What does that mean? Federal law says that occupancy can't be limited to less than 2 + 1 per bedroom. So that means you can have 2 adult occupants and 1 child per bedroom. So if you rent to me a 1-bedroom apartment, it's just me, I can move in my brother and I can move in my brother's kid, and you cannot terminate for that. You can require my brother be screened for anything other than ability to pay. You can require he be screened for criminal history and for other violations that would offend the screening guidelines we went over a minute ago above. You can require my brother sign a temporary occupancy agreement that makes his occupancy contingent upon my occupancy. So if I go, he has no right to remain there after my occupancy ends. Ultimately, this rule was put in place both because of COVID and the fires. And this rule sunsets after February 28, 2022. So at that point, the occupancy rules go back to normal. So you can still send a balance due requirement to the tenant. That balance due notice says, hey, tenant, I want to let you know that you owe $19,385, I'm making that up, from the emergency period from April 2020 through the present. Note that eviction for non-payment of rent during that emergency period is not allowed before February 28, 2022. That language is required. So one of the big changes that was secured by the lobbyists for the Rental Housing Alliance, Multifamily Northwest, and others is that all 4 of your stated cause notices are now permissible. What does that mean? It means after the first year of the tenancy, you can send a 90-day notice of termination for one of 4 reasons. Number 1, you're demolishing the property or removing it from the rental supply. Number 2, you're doing substantial renovations during which the premises will not be safe or habitable for occupancy. Number 3, you're moving in yourself or an immediate family member. Or number 4, there's a contract of sale to a buyer who wants to move in and use the property as a primary residence, but that contract of sale needs to be separate from any other dwelling unit. This last phrase, separate from any other dwelling unit, has been subject to increased scrutiny in the last couple of months. Ultimately, if I'm buying a duplex and I want to move into one side, tenants' lawyers are arguing that I can't do it because that particular stated cause rule says that the purchase needs to be separate from any other dwelling unit. That's been in the statute for as long as that statute's been around, for a little over 2 years now, but it's been largely ignored. Note that in Portland, you're required to pay relocation funds between $2,900 and $4,500, depending on how many bedrooms are in the property. That payment is per dwelling unit, not per tenant. So if you have 4 people in a 3-bedroom, they get paid a total of $4,500. You write that check to all 4 of them jointly. You let them figure out how to negotiate it. Under House Bill 4401, where the first year of the tenancy ended between April 1st, 2020 and August 31st, 2021, the first year of the tenancy was magically suspended until August 31st, 2021. That means that after June 30th, the landlord can send a no-cause notice to a tenant whose first year would have ended between April 1st, 2020 and August 31st, 2021. So logically, it doesn't make much sense. They've been there for 2.5 years if their tenancy ends on August 31st. But your ability to serve that notice was simply suspended. If it's outside of Portland, it's a 30-day notice on paper, but you can't terminate their tenancy until August 31st. So in practical reality, it's a 60-day notice. If it's in Portland, you got to send them a 90-day notice, so it ends at the end of September. It does not actually end on August 31st. But the upshot is your non-renewal notice for the end of the first year is available in July, after this emergency period ends. This is one of the things that we're most concerned about in the event that the governor unilaterally extends the emergency period. In a rational world, that would not occur because Oregon is a supermajority of one party, which happens to be the governor's party. And the governor's party debated Senate Bill 282 for several months, and they chose not to extend the emergency period. But the hearing that occurred the other week made the landlord's advocates concerned that the tenant groups were trying to, in essence, shame the governor into extending it because the governor has political cover. She's not up for re-election. The legislators are up for re-election. So that is the reason why the landlord groups were kind of a little worried that this hearing with no bill at issue was a charade. designed to put pressure on the governor. And that's why, and I saw several of you give looks of exasperation when I said it might be a good thing if Julie Fahey's bill passes. If Julie Fahey's bill passes, which would prevent a landlord from serving a notice of termination for non-payment, where the tenant can show that they've applied for emergency relief. If that bill passes, it leads us to believe that there's less of a threat that the governor is going to unilaterally extend the emergency period. And as I stated earlier, landlords are the only groups that were required to use private resources to protect the public for the pandemic. They took a public good, meaning, it was a legislative priority to keep people housed, and they made private actors, landlords, you guys who are on this presentation, they made you guys bear the cost of that. And they made you bear the cost of it in full. They didn't say that landlords have the ability to not do repairs. They didn't come up with a creative solution, such as that this was what I had actually sent a letter to our lobbyists to submit to the governor and to the legislature, and I don't think it went anywhere. But what I wanted was tenants to be required to pay 25%, landlord to waive 25%, state pay the landlord 25%, and then waive the landlord's property taxes. And then whatever was left, we'd get to the end of 16 months now, and the tenant would owe 2 to 4 months worth of rent. And that's plausible, that a lot of tenants could pay that back. What we're going to end up seeing, because of this situation where a lot of tenants owe 16 months worth of rent, we're going to see a wave of evictions for non-payment in July. And then we're going to see another group of people drag this out and pay rent for July for several months thereafter. And then they're just going to disappear when the grace period ends at the end of February next year. And again, the landlords are going to be left holding the bag for that. The other thing I want to note is that we're also seeing an increase in frivolous litigation asserted by tenants. And I just finished a case that ended up taking over 3 days to get through trial. So for context, my average bill to a landlord at the end of a full-blown eviction case is typically less than $3,000. It can cost substantially more than that. I just finished one that cost almost $23,000, and it's still going. And the reason it went on for so long is the tenants got a lawyer, a guy named Frank Wall, and the tenants had destroyed the property. We had before photos, we had during photos, and we had after photos. And after as part of a 30-day notice of termination for cause, you need to put a cure date. The tenants allowed us to enter on the cure date, inspect some of the property, but not all, and there was new damage. And the day after the cure date, the tenants intentionally flooded the property. So literally they pulled up the ballast in the back of the toilet bowl and it just flooded, causing hundreds of gallons to go over the back of the toilet through the bathroom. And there's a plaster ceiling that started to collapse. And the tenant's lawyer filed all sorts of frivolous motions, and the judge ruled in our favor on basically all claims. They raised claims for discrimination. They raised claims for retaliation. They raised money damages for diminished rental value. They accused the landlord of entering without notice. We had to defend against all of that. We won those claims. Full disclosure, the judge gave them nominal damages of $400, even though each tenant had asked for over $20,000. we saw it because part of what tenants lawyers want to do is threaten to put landlords through the ringer because that ups the settlement value. Now, in this case, we had offered to pay each tenant $1,000 and give them 90 days free and waive all their unpaid rent. They rejected that. So it's unfortunate because the tenants did much, much worse at trial than they would have if they had settled the case. But of course, the landlord got stuck with a huge bill. That's part of the reason that I and most landlords' lawyers always have the settlement conversation with our client, that it's in your interest to try to settle the case. And I generally try to twist my client's arms to settle. Now, it's not always possible. We're also seeing an increase in legal aid and Disability Rights Oregon and those types of groups bringing similar cases for retaliation for discrimination. And that's in large part because they are trying to expand the envelope of what is actionable discrimination. Where normally to bring a claim for discrimination, I have to say, well, I am actually discriminated. I'm blind. I have some other condition that the landlord needs to accommodate. If the tenant brings that claim, the landlord is legally bound to cooperate and have a good faith discussion on reaching an accommodated response. But what we're seeing is claims saying that, well, tenant has some health issues, and gosh, if they're evicted, they're going to become homeless, and they're going to be at greater risk of contracting COVID. Well, that's not a legitimate basis to grant an accommodation. Fear of COVID is not a winning argument. But again, tenants advocates are trying to broaden the envelope, and it just simply creates more risks for landlords. Let's talk about those risks. Generally, tenants can get 3 months worth of rent and actual damages and attorney's fees if landlords screw up the form of notice. They, for example, if they send a no-cause notice before they're allowed to, or if they send a 72-hour notice of non-payment instead of the 10-day notice. The tenants have a defense if the landlord doesn't comply with the law. The tenants can seek injunctive relief to force the landlord to let them back in. And the retaliation penalty has been increased from 2 months rent to 3 months rent, or 3 times the actual damages. So you add all this up, and a landlord who's made some mistakes can get dinged with penalties of up to 6 months worth of rent. Now, the other thing I want to point out is in the case I mentioned earlier, tenants each wanted $20,000. A lot of that came from the tenant's argument that the landlord's agent wouldn't wear a mask when he entered the property. Well, that doesn't give a tenant damages. Generally, non-economic damages, what we talk about is damages for pain and suffering, emotional distress, those damages are not available in landlord-tenant law because we have these statutory remedies. Tenant has to show evidence that the landlord committed a tort, a civil harm. The landlord didn't fix the front step after I told him to fix the front step, and I fell and I broke my leg. That's a tort for negligence. In those facts, then a tenant can get non-economic damages. But in your typical landlord-tenant case, non-economic damages are unavailable. It doesn't stop the tenant from threatening them. And if the tenant threatens them, unfortunately, that's something that the landlord has to pay their lawyer to defend against, which is why these cases can sometimes become unwieldy. Again, it's not uncommon that you get an answer that raises 15 different potential counterclaims against a landlord. In actuality, maybe 1 or 2 of those claims are actionable, but because tenants lawyers typically don't get paid by the tenant, they get paid by the landlord if and when they win. Because we're in that dynamic, they bring a kitchen sink approach and they force the landlord to have to respond to all of it. It's unfair, it's extortionist, but that's what exists. Okay, so the moratorium, the emergency period has already lapsed. After February 2022, the law reverts to what it was before the emergency period. That means that instead of a 10-day notice of non-payment, you can send a 72-hour notice. Some mandatory language in the summons and complaint, that disappears. Between now and then, what can you do? Well, you can send a 24-hour notice of termination for outrageous conduct, such as causing substantial damage or inflicting serious injury. You can send a 24-hour notice of termination to an unauthorized occupant. So what that means is if you have a tenant on a rental agreement, that tenant leaves, the rental agreement prevents subleasing, the landlord was unaware of other subtenants, and the landlord has never accepted a dime from the other subtenants, then the landlord can send a 24-hour notice of termination for unauthorized occupants. You can send a 10-day pet notice. You can send a 30-day notice of termination for cause, such as causing damage, having pets. Before Senate Bill 282, it included unauthorized occupants, smoking violations, other violations of a rental agreement or Oregon law are all actionable. Where a tenant cures a 30-day for cause notice, but then reoffends with the same or substantially similar conduct within 6 months, the landlord can send a 10-day repeat notice. So for example, if a tenant breaks holes in the walls, cures that notice somehow, but then within 6 months there are more holes in the wall, new holes, then a landlord can serve a 10-day repeat notice. Entry is still allowed. A landlord can serve a 24-hour notice of entry. If a tenant denies that, the landlord can serve a 30-day notice of termination for cause. As Scott Dallinger mentioned earlier, cash for keys offers are still allowed. Unfortunately, it's not effective in 100% of cases, but it is effective in the vast majority of cases. A lawsuit for arrears when a tenant has vacated the premises. Again, that was allowed for a brief period. There's a question mark here because while the tenants advocates during the passage of this bill said that once they're no longer tenants, you can sue them for the balance, the bill seems to be drafted more broadly than that. But I don't know. Other landlords' lawyers don't know. This is a topic that I'm speaking with frequently to other landlords' lawyers to try and figure out the scope of this bill and whether or not it covers folks after they're gone. So this photo here is an actual photo that a client of mine got because they were friends with their tenant on social media. The tenant said they couldn't pay rent. They submitted the declaration. The very next day, the tenant put this up on social media because he sold a bunch of dirt bikes. And the tenant put up on his, I think this was on Instagram, on his feed that there will always be a bill that I can put off. So the landlord could not terminate that tenant for non-payment, despite what appears to be several $1,000s. Obviously, the tenant wasn't interested in paying rent. Our remedy here was to report fraud to the Oregon Housing Community Service Department. What will they do about it? I don't know. Will the Oregon Department of Revenue audit the guy? I don't know. We just don't know how the state is going to follow up on all this. So here at the end of the presentation, again, this is for your information, and this is still required through the end of June, is the notice of eviction protection that needs to go out with any notice of termination for non-payment through the end of June. And then following that, the declaration of financial hardship that the tenant was required to complete and send to the landlord. Again, this is only required through the end of June of this month, although there's reason to believe that tenants may still require or may need it in order to apply for compensation funding afterwards. So with that, that is the end of the presentation, because I wanted to leave a little bit of time for questions. I'll note that I am out of the office on my first family vacation in 2 years. I come back on Sunday. So if you want to email me questions that you don't get a chance to ask, my email and phone number is right here at the bottom of the presentation. And I know that I've sent a copy of this presentation to Nicole Corwin with the Westside Investors Network. So if you need a copy of it, you can either email me or you can ask Nicole. But with that said, we've got a couple of minutes. So does anybody have any questions?
First of all, Charlie or Charles, thank you. I know I definitely learned a lot, and I always do whenever you talk, so I appreciate it. I had a question going back to the whole screening process of tenants and the rule that you can't use past evictions and criminal convictions against someone in the screening process. You listed a bunch of crimes that are not allowed when it comes to screening. It pretty much sounded like everything that I could think of. Are there any crimes that could still be held against applicants?
Oh yeah, so number one, the city of Portland has what they call the FAIR ordinances, that if you do business in Portland, you need to be aware of those because they have a whole separate set of rules. But just talking about general state law, if it's a misdemeanor within the last 5 years or a felony within the last 7 years for person crimes, rape, assault, murder, or crimes of dishonesty, fraud, identity theft, those can be used against a tenant. Similarly, if there are pending charges for those types of crimes, those can be used against a tenant. So in the what I listed above, that was meant to reflect that the enumerated crimes can be used against a tenant.
Okay.
So I apologize if I was unclear in laying that out, but those generally can be used against a tenant. What you generally can't use are, DUI, things that don't affect a third person or don't reflect on my ability to be a tenant. Or, it's not uncommon you get a request for accommodation that says, I'm a convicted rapist, but I got off parole and probation over 10 years ago. So that felony is more than 10 years old. I haven't had any new offenses. I successfully completed parole and probation. And those crimes were because I was an addict. I went through counseling. I went through treatment. I haven't had any new crimes. So you need to grant me an accommodation and ignore those convictions because they're more than 10 years old. The facts I just laid out are particularly egregious, and a lot of landlords may not want to grant it. But that's the type of thing that you hear when a tenant asks for an accommodation to ignore those crimes. But yeah, generally speaking, person crimes, things that reflect upon honesty or things that reflect upon someone's fitness to be a tenant, misdemeanors within the last 5 years, felonies within the last 7, those are things that can be used against a tenant in screening.
Got it. Okay. Thank you.
You started to talk about the idea that all evictions are now called into question between, I believe it was February 2020 and March 2022. What does that necessarily mean or look like when there is a situation where a tenant has, violated the agreement that they signed and they've been served what used to be the proper notices in order to, evict them? Is that
It means that if you're reviewing my application today and I was evicted for burning down the property last month, you cannot consider that.
wow. Okay.
No evictions between basically March 13th of 2020 and June 30th of 2021 can be used against the tenant, period. Again, that's not what the landlord advocates were told, but that's what's included in the final bill.
Okay. Thank you.
Hey, Charles, this is Matt from Columbia Asset Solutions. Thanks for taking the time. Quick question for you. We have a situation where we applied for the LCF funds for several tenants. Some of them and we were approved. However, they moved out prior to the funds being received. Is that going to affect the ability for us to use those funds or to apply for additional ones since they haven't paid any termination fees or additional fees of that nature? Can you speak a little bit on that?
What I would do is I would cash the check and accept the funds through the vacate date, and funds that are for time after the tenant actually left, you're required under the terms of your application to that program to return those funds to the Landlord Compensation Fund. Now, I will note that the latest round of funding that came after Senate Bill 282 does allow for some future rent. And it may be that if there was past due rent from before the period of time that you were compensated for, the compensation fund may let you keep that. But what I would do is be perfectly transparent. I'd call them and I'd follow up with an email so there's a written transcript and tell them, hey, I applied for funds from January 1st of 2021 through June 30th of 2021, and the tenants left on June 10th. So I got 20 days of extra money. My understanding is I'm supposed to return that. What do you want me to do? Because again, you could be brought up on, I don't want to say fraud charges because that's incorrect, but they could bring a civil claim for compensation, money had and received, unjust enrichment, that type of stuff. So I'd create a paper trail and I'd be prepared to return those funds for any day after tenant was gone that you received payment for.
And that's great. Okay, good. Is there any way we can also use those funds for anything other than rent? So pet fees, RUBS income, parking, anything like that?
If they let you, yeah. I mean, again, I'd have that conversation because your perspective is I was only allowed to apply for rent. I'm going to sue these people as soon as I'm available for all these other things. Can I apply the funds? And hopefully they'll let you keep it. We just don't know.
Got it. Okay. Thank you.
Good luck. And if they do let you keep it, send me an email. Let me know.
Okay. Will do.
Charlie, this is Scott. I have a question. When the moratorium ends, you on one part of your slide, you had on the 8th day of July, landlords can now serve a 10-day notice of non-payment. And then right below that, you said that fees and security deposits can be sought with a 30-day notice for cause. So is it 10 days or is it 30 days, or are those talking about two different things?
It's two different things.
Actually,
it's two different things. So just for purposes of this example, I'm going to talk about a 72-hour notice of termination for non-payment of rent. That's rent items only. Any other non-payment item, you need to pursue using a 30-day notice of termination for cause. The 72-hour notice of non-payment under the COVID response is extended to give the tenant basically a little more time to apply to the funds to get out of it. It's become a 10-day notice, but rent has always been separate from other non-payment items in terms of the landlord's ability to pursue it. And I guess I would just make a distinction because many of you do business in Washington and California. In those states, it's just a notice of non-payment for any item. But Oregon makes the distinction. They separate rent from other items of non-payment. Basically, if the tenant's supposed to pay you electricity and doesn't, you don't get to use that faster form of notice. You need to give them that 30-day notice to get it paid.
Thank you, Charlie.
You're welcome.
Any other questions? No, we are right at 7:32. So perfect job, Charles. We love it. I will have, I'll have a copy of this for anybody that wants the recording too, because there was a lot of great information. So thank you. And just know those of you that want your credit hour, you'll be getting that in the next couple of days. So thank you, Charlie, for being, this is the second time you've been on this, speaking for us and giving us great information. So thank you for that. And
Thank you for having me.
yeah, you're welcome. And Trent and Scott and Nicole. And who am I missing? Taylor. Thank you too. So you guys have a wonderful night and reach out to any one of us if you have questions.
Absolutely. And you can find this recording along with all the other WIN recordings on westsideinvestorsnetwork.com. Also check out the Westside Investors Network podcast hosted by AJ and Chris Shepard.
Thank
Have a
you.
great night. Thanks, Charlie.
Bye, everyone.